All right, welcome back. This is Chapter 7 for your Criminal Justice Course 352, Crime and Jurisdiction. Want to make sure that this is a chapter that we're going to discuss searches and seizures of things as it pertains to persons and things. We're not dealing with motor vehicles yet. We specifically deal with that in a later chapter. I will talk about motor vehicles to make sure you understand the differences, but we're going to start with, again, we're going to basically focus on persons and things. So we're talking about the right to privacy when it comes to searching something that you don't want the government looking into. So the right to privacy is not specifically mentioned in the Constitution, but it is inherent in the wording and in the interpretation by the U.S. Supreme Court. For instance, if you read the Fourth Amendment, it does not say that you have the right to privacy, but it says you have the right to be free from unreasonable searches and seizures. So therefore, the right to privacy is inherent in the wording of the United States Constitution. Okay. To have privacy, it must be a place where society recognizes you have the right to privacy. So you must, it's where do you enjoy a reasonable expectation of privacy? So like in your home with the windows closed, if you decide, whatever you decide to do behind closed doors, it's okay. Because you have a reasonable expectation of privacy there. If you take your blinds or your window curtains and you open them up and display something like, let's say you decide you want to grow marijuana, it's a good idea to keep your windows closed. If you open your windows and the police or anybody else can walk by and see, then you have failed to exercise a reasonable expectation of privacy, and the police can look and see that, and that's enough for them to get a warrant and kick your door down. But if the police were to break in your house to look to see that if you have that marijuana with your windows closed, that would be a violation of your right to privacy. So it comes down to is it a reasonable expectation of privacy that society is willing to recognize as reasonable? For instance, if you get in your car and drive somewhere, you still have a reasonable expectation of privacy, but that is a lesser because you've chosen to put yourself out into the public eye. The definition of a search is essentially it's an exploration or examination of something by the government looking for evidence, and the purpose of looking to find that evidence is for use in a criminal prosecution. We have to understand that the Fourth Amendment is portable. You take it and you put it in your pocket. So if you're following along with the Chapter 7 PowerPoint, you'll see a case called Katz versus the United States. So what happened in Katz is there was a man on a payphone, and he was transmitting. He was calling across state lines, providing numbers. He was a bookie, and that's illegal. So it's a sports betting operation, and that is a violation of the law, but the police the federal government suspected he might be using that phone booth. So since that phone booth was in the public, they decided to put a wiretap on it, and they did not get a warrant for it. They got enough evidence to convict Katz, and that was eventually challenged. The police position was, hey, it's out in the public, so we don't need to get a warrant for that. It's a public location. But what the U.S. Supreme Court had to do is say, does a person have a reasonable expectation of privacy in a phone booth, whether the door's closed or not? And if you don't remember what a phone booth was or is, look it up. It's, there's these things that used to be all over the public because nobody had cell phones in their pockets because they didn't exist yet. So the Supreme Court did decide that the Fourth Amendment, that it is portable. You carry it with you. So if you walk into a phone booth and have a private conversation, the government cannot listen to that without having obtained a warrant for a wiretap. So they threw the evidence out, or that was subject to the exclusionary rule, which we covered in Chapter 4. The government taking something is just the definition of a seizure, exercising control over that item and taking it into their custody. And again, they usually do that for the purpose of criminal prosecution, but sometimes they'll do it for the purpose of seizing it, keeping it, and selling it, or using it for their own purposes, such as under situations like it's called asset forfeiture. So if you are a really successful drug dealer and you buy a house, a yacht, a mansion, and the police find out that that's how you bought it was with the illegal drug proceeds, they can actually seize that and take it and sell it or repurpose it for the purpose of assisting the government because they don't want to let you keep that money. So To conduct a search or to make an arrest, generally the police need a warrant. So search warrant, there's two types of warrants. There's a search warrant and then there's an arrest warrant. A search warrant must have probable cause, as in articulable facts that would lead a reasonable person, police officer, or the judge to believe that what you're looking for is where you're going to find it. An arrest warrant is the same thing, articulable facts leading a reasonable officer to believe, leading a judge to believe that the person that you want to arrest is a person who committed that crime. And that's just simply an affidavit, an application with articulable facts leading to the probable cause, which is more likely than not. 4 types of things that can be seized in a search warrant. You have contraband. Its mere existence is illegal. For instance, if you're in a jail, usually most jails now are tobacco free. So the presence of tobacco is contraband. It's illegal. So that's an example. Most of the time, almost anything can exist, legally in some aspects. For instance, cocaine. There's no medical use for cocaine, but cocaine can be used in laboratory testing, in a certified lab for the purpose of testing, the effects of cocaine and so forth. It can actually exist legally in a toy for a dog for police to use, so they can, train their dogs to detect the presence of cocaine. So that would be contraband. Something, again, by its mere existence in a specific location is illegal. Fruits of the crime, like if something's stolen, that would be a fruit of the crime. Instrumentality of the crime, burglary tools, crowbars, blowtorches, whatever is used to perpetuate the crime. And like methamphetamine production, laboratories, and a house or wherever they make it at. And then you have mere evidence of the crime, which could be anything: DNA, blood spatter, the murder weapon, which would also be considered evidence of an instrumentality of the crime. The scope and the manner, if you get a search warrant for a piano and you start looking in the desk drawer, that's not a valid search because a piano will not fit in a desk drawer. That's why there's kind of a running joke among law enforcement. If you get a search warrant, let's say you get a search warrant for a stolen television, but you really would like to have a look in the house for drug activity. Well, you can't open up drawers and look in under beds and stuff like that if you're looking for a stolen 55-inch, Samsung. So make sure the joke is basically make sure you describe the TV that you're looking for and make sure all TVs have a remote control. So you're looking for the remote control for the television as well, which will fit in the bottom of a desk drawer. So you can open up all the desk drawers, and while you're looking in there, if you see evidence of drug activity, that is okay for them to find. Even though the police, they're being a little bit sneaky. Not a little bit, they're being a lot sneaky, but those are the rules that we're given, so that's technically okay. Once a person has been arrested, no matter what they're being arrested for, such as, let's say you get arrested because you forgot to pay your seatbelt ticket. It's a very minor traffic offense, and it's not, it's a minor arrest, and there's no reason to believe that you have methamphetamine in your pocket. But in accordance with the law, Chimo v. California, it's called search incident to arrest. So the officer can search for evidence of anything, and also what they want to make sure that the person's not carrying any weapons. So a search incident to arrest of any person who's arrested, as long as there's probable cause, is okay. So let's say a police officer does stop somebody for not wearing their seatbelt, and they realize, hey, he's got a bench warrant, a traffic warrant for not paying a prior speeding ticket. Well, the officer's going to search that person incident to arrest once they take them into custody, and if there's methamphetamine in their pocket or a murder weapon or whatever, that's okay. But let's say the officer made the traffic stop for something that they should not have been able to make the traffic stop for, like, they stopped him for speeding and the officer didn't know that the actual speed zone, they weren't actually speeding. That would be a stop without probable cause and could result in the evidence being excluded that was found search incident to arrest, and then being put, and resulting in them being put in jail. So I consulted on a case not too long ago where an officer made a traffic stop for a traffic violation that just wasn't a traffic violation as described. The officer just didn't quite understand the law, and the guy pulled over, and the officer discovered that he had been drinking, that he was intoxicated. He was obviously intoxicated, but the reason for the stop was a traffic violation that just was not actually a traffic violation, so therefore there was a traffic stop with no probable cause. All the evidence found after that was excluded, so none of that can be allowed in. Again, but a search incident to arrest, everybody gets searched after the arrest. Now, if there is a search warrant, they do expire. They cannot last indefinitely. It doesn't mean you just get to go to the house over and over again and search the area. Usually a search warrant cannot be executed past roughly, usually it's 2 weeks. There's a deadline given on the warrant. Each jurisdiction has their own set of rules, but it's not an indefinite search. If the information becomes stale, or if the item is found, let's say you're searching for a stolen big screen TV and you walk in and there it is with the remote, the search is over. The rest of the home cannot be searched because there's no probable cause to believe that the stolen TV is in any other part of the house because it's already been found. So it does not last indefinitely. If there is an arrest or a search without a warrant, the burden for, if there is a challenge, if there's a motion to suppress later, the burden to prove that there was probable cause falls on the police. Well, it's always better, even though it mostly doesn't happen this way, it's always better to get a search warrant, especially if it's an important case. Stop what you're doing, get a search warrant. I was searching a vehicle on the side of the interstate, and it had a massive amount of evidence in it. But about 20 or 30 minutes into the search, I said, you know, I've had enough of doing this on the side of the road with cars coming by at 70 and 80 miles an hour. We're going to go ahead and stop this search, even though I could continue the search without a warrant under the vehicle exception. We moved it to a secure location and still did not technically have to get a search warrant, but in the interest of being, you know, making sure that the case would go forth and we'd be able to use all the evidence that we found in the vehicle, I went ahead and got a search warrant after we secured the vehicle, and it was actually Jeff Davis Parish impound or CID building, and we continued the search after we got a search warrant. But if you get a search warrant, the police get a search warrant, the burden falls on the defendant at that point to prove that there was no probable cause. And if a judge signed it, that's pretty much it. So it's very hard if a search warrant is obtained. It's much easier to win a motion to suppress for a defendant if there was no warrant obtained. There are 7 exceptions to the rule that searches and seizures must be made with a warrant. So there's searches with consent exception. Again, if a person waives their right to be free from unreasonable search and seizure, that's called consent. So if someone's, you know, if the police pull you over in your car and you say, hey, can I search your car? And you say yes, what you've actually done is said, well, I'm going to throw my constitutional rights out the window, because that's an unreasonable search. It's a search without probable cause, without reasonable suspicion. Therefore, you can do it voluntarily, but you can waive those constitutional rights and allow that to happen. I have stopped people before. Stop someone for speeding. They get out of the car. I detect a strong odor of marijuana. Well, that gives me probable cause to search the vehicle. But I always ask, you know, just to see what their reaction was and to see, you know, and as an extra layer of precaution, you know, hey, can I search your car? If they say yes, that is a legal way to get into the car. And also the odor of marijuana is also probable cause. So if there's ever a challenge later, they have to defeat 2 challenges, not just one. And I've asked people, you know, hey, can I search your car? And they say no. I say, well, I was asking just to be nice because I do detect the odor of marijuana in the car, so I'm going to search it anyway, and may or may not find something. You also have searches incident to a lawful arrest. That would be anytime someone's arrested for anything, the police have the authority to search that person in their immediate lunge area to make sure that there's no evidence or weapons. Exigent circumstances exception. For instance, if a police officer goes to a house because somebody said, hey, there's somebody inside, and I think the husband is beating the wife or whatever, and the police pull up and hear a woman screaming, the police can go in, search that residence without a warrant under the exigent circumstances to protect the public, a member of the public, to protect the police, and or anybody else, to make sure, you know, they're not going to wait on a warrant for that to happen. While waiting on the warrant, the victim could be killed, so they can go ahead and do that. Now, once the scene is secure, they get to lock it down, and then they can go get a search warrant after that. A stop and frisk exception. No warrant is needed for a stop and frisk, but reasonable suspicion is required. So a police officer can't put their hands on somebody unless they have, for a pat-down search for weapons, unless they have articulable facts leading the officer to believe that that person is armed under a lawful detention. Motor vehicles exception. A motor vehicle falls under the Carroll Doctrine, which was, I believe, the Carroll case in 1925. The police searched a vehicle without a warrant, and the Supreme Court said that was okay because the vehicle can be driven out of the jurisdiction very quickly, therefore no warrant is needed. But there still must be probable cause. So if the police search a vehicle without probable cause, evidence is not admissible. It's okay to search it without a warrant, and that's how most vehicle searches are done, either with consent or with probable cause. Like, let's say you pull somebody over for speeding. That just speeding does not give an officer, a probable cause to search a vehicle for drugs. But asking for consent and they say no, you run a dog around the car, the dog alerts. That's actually probable cause, and it happens that way a lot. Special needs exceptions. So special needs exceptions are situations like running a school. So they don't need probable cause to search a student's locker at a school, when a drug dog alerts, because it falls under the special needs exception. Or searching a prison facility, even coming into a prison facility. You walk in as an employee or a guest, you're going to get searched, sniffed, checked to make sure that you're not bringing in illegal contraband, and there's nothing needed there. Even what else falls underneath the special needs exception is DWI checkpoints. So the government has a legitimate governmental interest in reducing impaired driving fatalities. So that can result in searches or a brief detention of a person at a checkpoint to make sure that they're not driving drunk, and the officer can detain the person until they determine that they're not drunk. Now, they don't have to prove that they're not drunk, but the officer still has to prove that they are. But the citizen is still required to stop at that checkpoint, and some level of cooperation, such as rolling down the window, is going to be an okay requirement. Producing ID, depending on the circumstances. But if they roll up and there's a beer can in the console, and there's an odor of marijuana, that special needs exception went from, I don't really need anything to stop this vehicle, to, hey, wait a minute, I've got reasonable suspicion that this person might be drunk driving. So there we've got a possible criminal activity, and can extend that DWI checkpoint brief detention into a reasonable suspicion investigation into criminal behavior. And then administrative searches and inspections exception, that would be something like wildlife and fisheries, checking boats. They'll pull over a boat on the water to inspect their fish, to check their life jackets and safety equipment that they're required to have. That's okay. No reasonable suspicion is necessary. No warrant is necessary. And a lot of people believe that the wildlife and fisheries can go in your house at any time. They don't need a warrant, stuff like that. I'm still trying to figure out where that myth came from, but it is a myth. And so I used to train wildlife and fisheries to be SWAT operators when I was with State Police SWAT. And so I asked them, I said, why do people think that you can just go into their house without a warrant and so forth, that you just have these special set of rules for you? And their answer was very simple. They don't know either. So people believe that. It's a rumor, it's a myth, but people believe it. So they knock on people's doors sometimes, say, hey, can I come in and check your freezer, look at your gun or your bow or whatever it is? And they say, yeah. A lot of them don't know that they can say no, but you can definitely say no. But it's a myth. But anyway, but checking a boat without reasonable suspicion or probable cause is okay without a warrant. Another example would be pulling over 18-wheelers. Law enforcement can pull those over to inspect their brakes and make sure that they're in compliance, because there was a time, and I'm sure they're still doing it, they'll disengage their brakes on their trucks and just use the brakes on the trailer to bring a vehicle to a stop, which is perfectly fine as long as you don't have to stop abruptly. But it saves the operator of the truck from wearing out his personal truck brakes. But if they need to slam on the brakes for something that stops in front of them suddenly, they can't. Everybody dies, so it's kind of a safety issue. So they're allowed to be pulled over and inspected, or even weighed to make sure that they're not carrying too much weight. Okay. Again, we've talked about consent a little bit. If consent is obtained, that's again a waiver of the constitutional rights. But there was a case in 2006 where there was two people present. One person said it was okay to search, and the other person said it was not okay to search. And that went all the way to the U.S. Supreme Court. The police went ahead and did the search while, we'll say, I don't know the exact scenario, a husband and wife are having a fight. Wife says there's cocaine on the nightstand. Husband says, and you can go search for it. Husband says, no way, you can't search for it, don't go in my house. Well, the police took her word and ignored his. So the Supreme Court had to answer that question, is that okay? Supreme Court said she absolutely has the right to waive her constitutional rights. But he also had a reasonable expectation of privacy in that bedroom. So she could not waive his constitutional rights. And that's essentially what the police allowed her to do, is to throw his constitutional rights out the window. So they said no, they excluded the evidence. Now, there's a way around that. So the court also said that if the person who says no is removed from the situation, that's okay, even if the police arrest him. So let's say the guy's got a bench warrant for not paying a seatbelt. Okay, lock him up, carry him to the station, and then ask the wife again, hey, can we search it? Technically, that's okay. It's a little sneaky, but again, we play by the rules that we're given. When the court tells us we can't do that anymore, then they'll stop. But right now, if there's a person present who has a reasonable expectation of privacy, they can deny that search, and the police have to honor that. Okay, there's something called knock and announce. So the police are required to knock on the door and announce in almost all situations. Otherwise, they do a no-knock warrant. So, but even if the police don't do that properly, the evidence is still allowed in. So, for instance, the police go to knock on the door and they have a regular warrant. They're not authorized to kick the door in without knocking, because sometimes, as a SWAT operator, we kicked a lot of doors in, and it was the safest option not to announce our presence, to overwhelm the target with a lot of cops, a lot of guns, and flashbangs. We ripped the windows out from the outside, drop a flashbang in every bedroom. We would kick the door in, drop a flashbang in the living room, and then make entry. What meant, making a lot of noise with 20 operators in a small house, just to make sure that we overwhelm the target, because that person has threatened violence. Or even there was one case that we went in, and Mamu, the guy had taken a hostage, said he was going to kill her if we came in. We believed him, so we waited. We tried to talk him out, nothing worked. We saw an opportunity to make entry, so we made entry. No knock, no announce, dropped a flashbang in, and he elevated himself, went for a weapon, and two operators in the front, and I was probably fourth or fifth in the stack. They shot him, starting from the lower torso, left side, worked their way up, hit him 17 times. It did kill him, but it had to be done, we thought, but it turns out when we got in, the hostage, she was already dead, so he'd already killed her. But sometimes, there's no reason to knock and announce. With that said, if the police violate the knock and announce rule, the evidence is still allowed in. It doesn't change the fact that there was a valid warrant, probable cause existed, and the search is still okay. Okay, we talked about administrative searches, and let's make sure we cover all this. Other issues in searches and seizures. So let's talk about the use of police dogs. Police dog is a valid method of establishing probable cause. The dog is trained to detect illegal substances, explosives, mostly drugs is what they're used for. So police can use those as long as they're in an area for which they are legally allowed to be. For instance, a cop pulls somebody over and he's got a canine in the back of his car and just feels like there may be drugs in the car. Well, in the course of the traffic stop, without extending the traffic stop, the officer runs the dog around the car, the dog alerts, that's probable cause to search the vehicle. There's been some questions that come up in the courts about taking dogs from house to house, knocking on one door, or going up to somebody's door, and the dog alerts. The dog can smell marijuana from outside the home. Actually, the home has a much greater protection than than a vehicle, obviously. A vehicle on a traffic stop, dog running around it, the vehicle is on a lawful detention, so that's a different story. But going stoop to stoop, the courts looked at that and said, that's not going to work. So public areas, the dog running around, it's okay. But stoop to stoop, no. Like when I say front door to front door and having the dog, and I always get a question, what if the dog is just playing in the street? Well, and your dog alerts, is that probable cause to get a warrant? It's probable cause, but it's not. You get a warrant with that, it's not going to hold up. You need to start finding another way to get the evidence to establish that you believe there's drugs in that house, like going through the trash, which is a good way, or doing getting informants, so forth and so on. Searches and seizures of computers, it's very simple. Text message, emails, any electronic communications. Get a warrant, get a warrant, get a warrant. Everything on your phone is computerized, or everything in the world is computerized now. It's secure, and people have a reasonable expectation of privacy in it. So you can't make somebody, put their face in front of the phone to act, as facial recognition, or put in their passcode or anything like that and search it without a warrant. I guess the only time that would be okay would be under an exigent circumstance. You pulled over, you somehow got a terrorist and the bomb's going to go off and you think information in the phone is there. You can do whatever it takes to open the phone, get the evidence under the exigent circumstances. Drug testing public employees does not require a warrant, but there was some public employees who didn't like that. I think it was a railroad company, public railroad company, and I guess they didn't want people knowing if they used marijuana, or whatever drugs they were using, but the courts have supported that they can be subjected to random drug tests and so forth. And again, that's a public agency. The Fourth Amendment is designed to protect you from the government, so Walmart doesn't count. If you work for Walmart and they want to drug test you and you say no, then they just fire you. That's okay. That's a civil matter at best. If you're working for a police department and they want to drug test you and you say no, well, you actually have constitutional protection because they're the police or a government agency, but the courts have supported that's okay. They'll still fire you, and it's okay to do that. It doesn't fall under the protection of the Fourth Amendment. Squeezing luggage in a bus is considered a search without a warrant. You can't do it. Searches and seizures by private persons. Again, if a private citizen searches your property illegally, breaks in your house, whatever, that has no Fourth Amendment protection. So if some burglar breaks into 40 houses and steals a laptop from each one and finds one of the laptops has child pornography on it, brings it to you, the police, and you can use that as probable cause. You can say, well, that criminal violated my rights. Actually, the criminal didn't violate your rights. The criminal violated the criminal code, and you're not protected. That's not a constitutional rights violation. Now, if the police did that, the police would be violating the criminal code and your constitutional rights. But a regular burglar who broke in your house and stole your laptop and turned it over to the police, that you're not protected from that. Off-duty officers. If there's a search by an off-duty officer, let's just put it in plain and simple terms. There's no such thing as an off-duty officer. If an officer is a member of the government, conducts a search, or is a member of the police, whether they're on duty or off duty, doesn't matter. The warrant is still required, or that's considered, protected by the Fourth Amendment. So those are a few more of the issues of search and seizures. Here's there's some places where you have no Fourth Amendment protection. So one of the only ones in the U.S. is going to be the border. Now, borders can be anywhere. Airports, international airports, where you fly in from another country. The border itself, Canada, Mexico, that's our ports. We have the Port of Lake Charles. We have Houston Intercontinental Airport. We have the south border of Mexico, the northern border of Canada. All those are places where there are no Fourth Amendment protections. So if you're trying to come into the United States from another country, it's actually okay for the police to do as it pertains to the Fourth Amendment. So if the Border Patrol guy comes up to the person and cuts them into a million pieces looking for drugs, it's not a constitutional rights violation. Now, he's probably going to get in trouble with his employer, with the Border Patrol people, but technically you can't sue and say, well, he violated my constitutional rights by cutting me up into a million pieces. Yeah, there's no constitutional rights at the border. Once you get inside the border, that's a different story. Like there was a case where a guy was coming in to the United States and he had a computer with him. He also had a prior conviction for child pornography. Just because you have a prior conviction of child pornography doesn't mean that's not probable cause to believe that you now have child pornography on every computer for the rest of your life. So there was no reasonable suspicion. There was no probable cause. But the police took it, sent it off, kept it for 2 weeks, searched it, found child pornography, and prosecuted him for it. And he said, that was an unreasonable search and seizure. And the courts agreed. That is an unreasonable search and seizure, but sorry, you were at the border. You have no Fourth Amendment protection at the border. So the evidence is still allowed in. He still gets convicted. He still goes to prison. Okay, that wraps up Chapter 7. It's around 29 minutes, so we'll pick it up in Chapter 8. Thank you.